And Mr. Cox, are you all ready to proceed?
We are, Your Honor.
Yes, for the legislative defendants, Your Honor.
We are as well for the state defendants.
Okay, looks like we have everyone here then and are ready to start back. Ms. Moss, you may ask your next question of this witness.
You hear me, Senator McKissick?
Yes, I can.
Okay. All right. If we could bring back up the exhibit that I was showing you, which was a printout from your website, a post on November 28th, 2018, LX 262. And you would agree with me that in that post that was posted to your website, that it states in part, today I was able to obtain bipartisan support for an amendment to the bill that extended the expiration date of these ID cards to 10 years. That is what you wrote or had written on your behalf on your website, correct?
That is correct.
If we could now look at LX 263.
Okay.
And this again is a post that was made to your website. Do you happen to recall this particular post?
Not really, no.
Okay. And the title of this post is "The Passage of the Voter ID Law and Real Voter Fraud in Bladen County."
Objection beyond the scope of rebuttal.
Your Honor, the post goes to Senate Bill 824 and its terms, which he testified about extensively on direct.
Hold on just 1 second. The objection's overruled. You may ask your question.
Okay. And in this particular post, if we go to the second paragraph on the second page, and I'll start with context that this particular post was posted on December 6th, 2018. And you begin, I guess, let's start at the first paragraph if we can, actually. You begin stating on your website that today Senate Bill 824, which implements our state's new constitutional amendment, which will require voter IDs in future elections, received a final vote in the North Carolina Senate, and it now has become the law of the state of North Carolina. I fully anticipate that Governor Cooper will veto this legislation and that his veto will be overridden during the special session of the North Carolina General Assembly. Today, protesters were present in opposition to our state's new voter ID law. And then you go on to say, there were a few changes made to the bill by the North Carolina House. The most significant one, in my opinion, will require the North Carolina State Board of Elections to adopt new rules relating to the requesting of absentee ballots in our state. In the future, a person will need to submit some form of photo identification when requesting an absentee ballot. I suspect the other changes to be made to the absentee ballot process. And this particular change was enacted as a result of the compelling evidence of rampant voter fraud relating to absentee ballots in Bladen County, North Carolina, during the November general election by a Republican consultant who was working on behalf of Mark Harris, who is a Republican running for Congress from the 9th Congressional District. And then it goes on from there. That is something that you posted or had posted to your website, correct, Senator?
Yeah, it appears to be.
Okay. And you would agree that it is a legitimate goal for the General Assembly to pass legislation to deal with, quote, rampant voter fraud, end quote.
Objection, Your Honor. This is definitely outside the scope. Ms. Moss, we didn't bring up voter fraud, and Ms. Moss represented should be asking questions about Senate Bill 824.
And Your Honor, he has expressed views as to why particular provisions in Senate Bill 824 were added to the legislation, in particular a provision that he wrote that he viewed as important to combating rampant voter fraud.
Not in his rebuttal testimony.
Okay, give me just one second. Overruled.
Okay, so what was the question again, if you could repeat the
Sure,
question?
Senator. The question was, you would agree that it is a legitimate goal for the General Assembly to pass legislation to deal with, quote, rampant voter fraud, end quote, correct?
Yes, but I say that with a explanation. What occurred down in Bladen County dealt with absentee ballots. I can actually recall reaching out to the Board of Elections at one point in time when this whole voter ID idea was being discussed, about the extent to which there were cases where a person went in and impersonated another person to vote. And as I recall, the information they provided me was that those type of instances back in 2016 only occurred in two circumstances, one involving someone voting in person and the other involving an absentee ballot. So, I mean, since that was being used as a pretext for voter ID, because there was this rampant voter fraud that could be addressed with voter ID, I thought that the whole basis and pretext for requiring it was flawed from its inception, because there was no rampant voter fraud dealing with voter impersonation issues. In Bladen County, you had a whole different situation dealing with somebody going out and requesting absentee ballots, and then the person picking up those absentee ballots, and it was unknown as to whether that person was then, getting them in sealed envelopes or unsealed envelopes, or how they were being delivered to the county board of elections. So it was a really completely different issue, completely, than something that voter ID would address. That's my recollections. I'm just going back from what was occurring at that point in time. Yeah,
And-
there's fraud. I mean, legitimate cases, and you do something about it. But the voter ID bill, in terms of a need for voter IDs because of voter impersonation, that was non-existent as a problem in this state.
Right.
You know,
But that's not what you were posting to your website on December 6th, 2018, correct? What you posted at that time was highlighting an important change to the law that, in your words, was enacted as a result of the compelling evidence of rampant voter fraud relating to absentee ballots in Bladen County.
Objection mischaracterizes previous testimony. He already said he didn't write this.
Give me just one second. Overruled.
yeah, I mean, what is expressed here was some concern about what was occurring in Bladen County. That's what I see in terms of what this was addressing, because of what occurred in Bladen County.
We
And I
can
mean,
take.
I don't know what else to say. I don't have perfect recollections of everything that was going on at that time, and so without having perfect recollections, it's hard to say without reading either newspapers perhaps from that period about what was going on in Bladen County, or what particularly was being addressed in terms of an add-on to deal with Bladen County and the Bladen County situation. As I say, I did not post this stuff to my website. There was a person who was a consultant who would put materials up on my behalf. So, I mean, I don't have perfect recollections as to all that was occurring in that time frame. So it's hard to, and I know this might come up. I could have gone back and reviewed it, become more acquainted, seen what might have been stated, otherwise by me in that period, or based upon information that was in the public domain in that period.
Senator McKissick, on direct, in response to questions that you were asked on direct, you referred to data that you had suggesting that there were 300,000 registered voters who lacked ID. What data were you referring to?
As I recall, it was data that was publicly available at the time. I think there was a professor who had done some research and had made a preliminary determination or assessment about the number of people that existed in the State Board of Elections website, and it contrasted it and compared it to those people which were in the Department of Motor Vehicles database as having either a photo ID type card or a driver's license, and that was the way that information had been derived. That's my general recollections as to the basis of that information, but it was information that was in the public domain at that point in time, and I recall reading a report or study or analysis or something that, as I recall, that was the basis for that determination, but it could have been other factors that I'm not remembering that went into that, into the potential computation of the number of people that would be adversely impacted.
Okay. You don't recall when that particular analysis was done or who did it?
Not without going back to independently check.
Okay. And you don't recall whether it's an analysis that was contested in the House Bill 589 litigation?
House Bill 589 litigation. That's going back 2013. I don't want to state what my recollections are that far back, and whether that was debated and discussed. I mean, I know that in that during the, and when you say discussions, are you talking about on the floor of the House or on the floor of the Senate or in litigation that would have been an outgrowth of that?
My question was, you don't recall whether the analysis that you're referring to is an analysis that was contested as part of the House Bill 589 litigation.
I don't recall.
And is there any other information or details that you can provide us today about this analysis that you referred to that suggested that there were 300,000 registered voters that lacked ID?
No, I think I've shared. I mean, I'm sure back in that time frame, I would have had a report or something that would have been the basis of that conclusion or that assessment. But without going back and kind of doing an exhaustive search of what I might have from 2013, it would be impossible to know that. But I frequently read documents and materials that were readily accessible that were dealing with these issues.
Okay. You also testified in response to one of my questions that your vote to table one of the amendments to Senate Bill 824 may have been a finger slip. Do you recall that?
Yeah, I do. I
In
said in
your
the worst case, it might have been, because I don't really remember that particular amendment or what it did or seeing its context within the broader bill. So, every once in a while, you're sitting there and it's been a long day and you might inadvertently vote the wrong way on something.
How frequently has that happened to you during your time in the Senate, that you had a finger slip and voted a way that you didn't intend to vote?
Occasionally, from time to time.
And when that happens, is there a way to fix it?
Yeah, you correct your vote, unless it's, in this case, it probably would have been inconsequential in some respects because it was tabled anyway. It wasn't like it was substantive legislation at that point in time. It was an amendment, but I only simply raised that because I could not recall what that amendment did or how it fit together. It could have been an intentional vote, or it could possibly have been a finger slip.
And you understand that if you didn't avail yourself of whatever procedures there are available to fix a quote unquote finger slip mistake, that becomes your official vote in the record in the Senate.
Absolutely. Absolutely.
Those are all the questions that I have, Your Honor.
Okay, Mr. Steed, do you have questions of this witness?
We do not, Your Honor. Thank you.
Ms. Riggs, do you have further direct questions of this witness?
Brief redirect, your honors.
And if I could just briefly, we want to make a motion, but we're happy to do it now or after Ms. Riggs' redirect, but we would like to make a motion to strike the entirety of Senator McKissick's rebuttal testimony, and I'm happy to be heard now or at the end of Ms. Riggs' redirect.
Let's hear Ms. Riggs' redirect first, and then we'll take up motions about this testimony.
Thank you, Your Honor. Senator McKissick, in the mere days available to you to debate and offer amendments on Senate Bill 824, did you have time to fully research and identify all the amendments you could have offered that would have been ameliorative?
No, I did not have sufficient time to do so.
And if you had addressed the bill during the long session, like the legislature did with Marcy's Law, would you have had more time to research and offer amendments?
Absolutely. I mean, we did it with Marcy's Law. We did it even a few years before then. I think it was back in 2014 where there was a constitutional amendment dealing with the waiver of jury trials for criminal defendants involving felony cases. You know, it passed. We came back. We worked on it. It wasn't any special session call. So, I mean, that was more or less our traditional practice during the time I was there.
Senator,
Yeah, go ahead.
Senator McKissick, on cross-examination, you said that Senate bill was an improvement over House Bill 589. Is that because Senate Bill 824 didn't have other provisions cutting early voting and ending same-day registration, among other things?
Absolutely. That was the purpose of intent of recognizing that.
And Senator, you testified that you added and voted for several amendments, but that following those amendments, though, you still did not vote for the voter ID law that was Senate Bill 824. Was that your testimony?
That is correct.
Why not? Why did you not vote for Senate Bill 824?
Well, because it really hurt people who are already lawfully able to vote, who did not have voter IDs or some type of document that was equivalent underneath the law. And it disproportionately impacted low wealth voters and African American voters. And it seems strategically designed and purposeful to do so. And us having this special session to come back in between Thanksgiving and Christmas to work on it basically sent a message to me that they were trying to get this bill signed into law before there was a veto proof composition of the Senate and the House. I mean, they would, that was the rush. They knew it would be more challenging to deal with these issues later. And it would have been far better to have dealt with it in the long session and to have provided the thought, reflection, the time, the research to come up with something that would mitigate impacts that were going to be occurring because of this new voter ID requirement.
No further questions. Thank you, Senator McKissick, for your time today.
Thank you.
Ms. Moss, further across?
No, Your Honor.
Mr. Steed, any other questions?
No, Your Honor. Thank you.
Okay. Ms. Moss, do you want to hear your motion now?
Yes, Your Honor, if I may.
I tell you what, before you do, Senator McKissick, thank you very much for being here. You're now free to leave the courtroom and go on about your day. I hope that you have a good rest of your day, sir.
Thank you, Your Honor.
All right, now, Ms. Moss.
Your Honor, our motion, It was not clear to us before now because Senator McKissick was not disclosed as a witness, and so we had no opportunity to depose him to know what his testimony might be. But it's now clear following direct and cross-examination that the purpose for bringing him back in rebuttal was to attempt to rebut testimony from Senator Ford. Plaintiffs made the choice and indeed insisted upon calling Senator Ford as a witness in their case in chief. It is not appropriate for them to then bring in a witness to rebut a witness that they themselves called. We opted and asked to have Senator Ford be a witness in our case. They refused that. They insisted upon subpoena him and having him in their case in chief. And so to the extent that they are offering Senator McKissick's testimony as a rebuttal to Senator Ford, that is inappropriate rebuttal, as it was evidence that they elicited in their case in chief. And for those reasons, we would ask that Senator McKissick's rebuttal testimony be stricken.
May I respond?
Ms. Riggs, yes, you may respond.
I have several points in response, Your Honor. First, we reserve the right to call any rebuttal witness. There was an agreement, first of all, in our motion to compel filed on 4/12/21, we noted that former Senator Ford's being called in our case in chief was going to be presented as a hybrid in order to address legislative defendants' concerns that they wanted to minimize the burden on former Senator Ford. And so the questions that Mr. Patterson asked Mr. Ford were questions that they would have elicited in their case in chief. The defendants opened the door by using statements of Senator McKissick in cross throughout the examination. And it is not the case that Senator McKissick was brought on solely to impeach former Senator Ford. It was also to impeach the expert testimony offered by Professor Callanan. And when legislative defendants make Senator McKissick a centerpiece of their defense and seek to mischaracterize his words, we believe it's an appropriate use of a rebuttal case to allow him to correct the record.
Mr. Cox or Mr. Steed, do you all wish to respond?
No, we take no position, Your Honor. Thank you.
All right, the motion to strike Senator McKissick's testimony is denied. Any other motions at this time?
Your Honor, we don't have a motion, but with the court's permission, there's a housekeeping matter I would like to raise.
Okay,
And it relates to the closing arguments, Your Honor. Mr. Cox and I have been in communication, and we think collectively our combined closes will take about 100 minutes. And if the plaintiffs take a like amount of time, that would be 200 minutes. And 4 hours times 60 is 240. So that leaves sort of a balance of 40 minutes. If we take our 2 15-minute breaks, that leaves a cushion of 10 minutes. And that should be enough time to deal with LX 188 and, the other evidentiary issues. But if it's not, we might ask the court, after we've dealt with those evidentiary issues, perhaps to take one break for 20 minutes. I just wanted to alert the court that we think we can fit it all in, but it might be a little bit tight.
Mr. Biggs, do you want to respond to that?
Your Honor, yes. I mean, I do think we have exhibits that some of which can be moved in with the remaining time. I understood the court needed to be done by 1 p.m. today. Is that correct?
Yes, and I think he was talking more about tomorrow.
Right. I guess, I'm sorry, Your Honor. My point was, I think there's some exhibits that we still need to work out and review and send back and forth. So there will be some evidentiary movement in the morning. We think this court has been so very generous in its time and consideration. We do believe closing can be done in less time, but our only request is that time be divided equally.
Well, they say they collectively would take 100 minutes, which I guess is 20 minutes shy of 2 hours. So that's an hour and 40 minutes, if my math is right. Do you think that you can get your closing done in an hour and 40 minutes?
We think it's more important that the parties be afforded equal time. My general guess is lawyers are always better when given a time limit. We'll have some rebuttal, I'm sure, after their presentations, but I can commit to the court that we would not go over whatever time limit you set, and whatever time spent by the defendants collectively.
Okay. Well, while we think about that, what evidence do you have to introduce today, if any, in your case in rebuttal?
Sorry, a truck just drove by. Mr. Simons, I'll turn over to my colleague, Mr. Simons, for that.
Thank you, Ms. Riggs. Your Honors, plaintiffs circulated a list of exhibits they plan to move in at the close of their rebuttal case to opposing counsel earlier today, and I can begin moving those exhibits in now.
Okay.
The first is PX 52, which is the supplemental declaration of Senator McKissick in the case of NAACP v. Cooper. Plaintiffs are not moving this in, or plaintiffs are moving this exhibit in to show that Senator McKissick made these statements and that they could have been relied on by the legislative defendants expert, Professor Callanan.
We object, Your Honor.
Okay, what's the grounds for your objection?
They're attempting to move in an affidavit of Senator McKissick. He was just on the stand. He was able these are out of court statements being offered for the truth of the matter. He was able to offer his information, and I don't believe that they asked Professor, I could be wrong, and I stand to be corrected if I am, but I do not believe that they asked Professor Callanan about this. So the fact that there's something that exists in the world that he could have relied upon, I don't believe that they brought that point up to him.
Your Honor, just briefly,
I have
I'm sorry.
a question whether or not Callanan made this a part of his opinion. Is that what you said?
Your Honor, Professor Callanan cited Senator McKissick as evidence of the bipartisan nature of Senate Bill 824.
The objection's overruled. I'm going to allow PX 52.
Thank you, Your Honor. Next on my list is PX 99, which is a Washington Post article about the Virginia election that Professor Callanan discussed on his direct testimony. This was also used during Professor Callanan's cross-examination.
We would object only to the extent that it's being offered beyond what the previous agreement was on materials that were asked of experts on cross or that they relied upon, and that it is otherwise it's hearsay, but if it comes in only for the purpose of the fact that it was used with Professor Callanan on cross the way other exhibits came in, we have no objection in that. Beyond that.
Is that the purpose for which you're admitting it?
Yes, Your Honor.
All right. PX 99 then is received to the extent that experts relied upon it in forming their opinion.
Thank you, Your Honor. Next is Exhibit PX 92, which is a paper authored by legislative defendants expert Professor Hood titled "They Just Do Not Vote Like They Used to." This was also used on plaintiff's cross-examination of Professor Hood, and it is being admitted to show that it was used during cross and that Professor Hood relied on it.
PX 92 is received for the purposes that the experts relied upon it in forming their opinion.
Thank you, Your Honor. Next is PX 111, which is a rebuttal report by Dr. Thornton in the Fair Fight Action case.
Your Honor,
Yes.
I guess we would object to that. That's not a report in this case, and it's not anything that she relied upon for purposes of this case. So we think it's beyond the scope.
Your Honor, we would just like to admit this report to show that Dr. Thornton has given expert testimony in other voting rights cases, not for the substance of the report.
I believe she testified to that on direct. I don't know that the report needs to come in to establish that fact.
Okay, PX 111 is received. Um, you're admitting it just to show that she's given other expert opinions in other cases?
Your Honor, if I can explain, that was in a line of questioning going to the witness's bias and the amount of credibility this court might afford the witness. So we talked about all of the cases in which she had offered testimony in favor of state defendants. It's a credibility question for this court.
Okay, then we would receive PX 111 for impeachment purposes. Is that a fair reason why you're admitting it?
I think we would accept it as such. It was to allow the court to make a full and a full determination of how much credibility it wants to afford to that witness's testimony.
Okay. Okay. What's your next one then?
The next exhibit is PX 107. This is another report that Dr. Thornton issued in another case, and we are moving it in for evidence for the same reasons as for PX 111.
We
Okay,
have the same objection, but understand the court's ruling.
the objections overruled. PX 107 is received for impeachment purposes.
Thank you, Your Honor. Next is exhibit PDX 4-11. This is just admitted for demonstrative purposes.
What is it?
It's a demonstrative that was used by plaintiffs on the cross-examination of Dr. Thornton. It is taken from the demonstrative that was used during Professor Quinn's direct examination, and it shows that few new matches were added to Dr. Quinn's analysis with Senate Bill 824's new forms of ID.
Okay, PDX 4-11 is received for demonstrative purposes.
Thank you, Your Honor. Next is PDX 6-2, which is a demonstrative that plaintiffs used on their cross-examination of Dr. Thornton that shows the BVAP percentage for counties without satellite one-stop early voting sites during the 2018 general election.
PDX 6-2 is received for demonstrative purposes.
Thank you, Your Honor. Next is PDX 6-3, and this was a demonstrative that plaintiffs also used during their cross-examination of Dr. Thornton, and it shows Dr. Quinn's composite match fields.
PDX 6-3 is received for demonstrative purposes.
Thank you, Your Honor. Next is PDX 6-4, another demonstrative that plaintiffs used during their cross of Dr. Thornton, and it shows the hypothetical matching analysis for the missing last 4 digits of a social security number.
PDX 6-4 is received for demonstrative purposes.
Thank you, Your Honor. Next is PDX 6-5. This was another demonstrative used during Dr. Thornton's cross-examination, and it is a hypothetical matching analysis for a missing driver's license number.
PDX 6-5 is received for demonstrative purposes.
Next is PDX 6-6, another demonstrative from plaintiff's cross-examination of Dr. Thornton. It shows a hypothetical matching analysis with a last name change.
PDX 6-6 is received for demonstrative purposes.
Next is PDX 6-7, another demonstrative from plaintiff's cross-examination of Dr. Thornton, and it shows that Dr. Thornton's string analysis cannot generate new matches.
PDX 6-7 is received for demonstrative purposes.
And next is PDX 6-8, which is, I believe, the final demonstrative that plaintiffs used during their cross-examination of Dr. Thornton. And it is titled Dr. Thornton's, quote, new matches, unquote, to the DMV database.
PDX 6-8 is received for demonstrative.
Thank you, Your Honor. Next is PX125, and that is an email chain from Paul Cox with the subject line production from 2019.
PX125 is received in the evidence.
Next is PX126. This is an email chain from Ms. Visotskaya from November 2020 to the plaintiffs.
PX126 is received.
Next is PX117, and it's an article titled Black Turnout Down in North Carolina After Cuts to Early Voting.
Objection, Your Honor.
Okay, what's your grounds for that?
This was a news article that plaintiff's counsel attempted to use with Ms. Strzok on cross. I do not believe that the court allowed her to question Ms. Strzok about this particular article, as it is hearsay. Ms. Strzok did not recognize the article, and plaintiffs moved to have Ms. Strzok treated as a lay witness, not an expert. So it would be inappropriate to have hearsay come in on the examination of Ms. Strzok.
Your Honor, plaintiffs request that this exhibit be admitted to evidence to show completeness relative to the questions that legislative defendants asked of Ms. Strzok about their exhibit LDX 0220, which was the demonstrative of Guilford County one-stop voting sites.
The objection to it coming in as evidence is sustained, but I will allow it in the record for purposes of preservation and to allow you to make a proffer.
Thank you, Your Honor. Next is Exhibit PX122, which is a list of one-stop voting sites for the November 4th, 2014 general election.
PX122 is received.
Next is PX121, which is a list of one-stop voting sites for the November 6th, 2018 general election.
PX121 is received.
Next is PX120, which is a State Board of Elections numbered memo 2020-14.
PX120 is received.
Next is PX127, which is an excerpt from the trial transcript from these proceedings of April 23rd, 2021.
PX127 is received.
Next is demonstrative exhibit PDX 5-2, which plaintiffs used during their cross-examination of Ms. Strack, and it is from Dr. White's demonstrative, and the slide is titled Poll Worker Decision Points.
PDX 5-2 is received for demonstrative purposes.
And the last exhibit on my list, Your Honor, is PX 134, which is a web page from Duke University's website that describes the Duke voter ID card available to students.
Objection, Your Honor. This is another exhibit that plaintiff's counsel attempted to use with Ms. Strzok in cross, and that the court sustained the objection. Ms. Strzok did not recognize the website and was not familiar with the information. And as she was testifying as a lay witness, we believe it would be inappropriate to come in, given that she is not being treated as an expert.
Your Honor, plaintiffs would seek admission of this exhibit to show that when Ms. Strack was executive director of the State Board of Elections, she approved Duke student ID cards for voting purposes under SB 824, but did not approve this specific Duke voter ID card. So this plaintiffs would like to admit this exhibit just to show that there were two types of ID cards available to Duke students that would qualify under SB 824.
And Your Honor, Ms.
I'm going to sustain the objection, but I will allow it into the record for preservation of the record and to allow the plaintiff to make a proffer.
Thank you, Your Honor. Those are all the exhibits the plaintiffs have at this time.
So to the extent that we're at that point, which technically we're not, because I think the defendants haven't fully rested their case in chief yet, but assuming that they had finished what they're going to do tomorrow, would the plaintiff now be in a position to rest its case in rebuttal?
I think so, Your Honor. I think there are three exhibits or three different documents that will be coming in the morning, and I'm not sure exactly whether they'll be plaintiff exhibits, joint exhibits, or legislative defendants. So beyond that, I would say we suspend and rest, except to the extent those documents that we reviewed today come in the morning.
Okay. Mr. Thompson, do the legislative defendants or do the state defendants have any objection at this time to, I guess, best way to say it is just to relax the rules of admission of evidence and cut off when you rest and so forth, such that anybody tomorrow could revisit the issue of introduction of evidence and not be objected to based on, oh, well, they can't admit that now they rested. You understand what I'm asking?
Yes, Your Honor, we're willing to waive any such objection.
Okay.
I don't have any objection to that either.
Okay, great. That just allows folks to be able to, not be constrained by the technical rules of when you're allowed to admit, so that when we come back tomorrow, no one would be prohibited from introducing further evidence, at least the legislative defendants and plaintiff's case in rebuttal. Maybe a different story as to plaintiff's case in chief, but let me just ask, will there be any rebuttal evidence, or I guess third rebuttal, perhaps is the best way to say it, from the legislative defendants?
Your Honor, we don't anticipate that at this time, but as Ms. Moss said, we did not have an opportunity to depose Senator McKissick. We were hearing his testimony for the first time, so we'd like to have this evening to think about that and get back to you first thing tomorrow.
Okay, if you do, that's fine. We may, if you do that though, do closings next week.
Understood, Your Honor.
So that makes things are scheduled.
Just for clarity of the record, Your Honor, we disclosed Senator McKissick very early, and they did on Saturday or Sunday, and we're prepared to offer him for deposition, to sit for deposition. They never asked to take his deposition.
Okay, well, we can address that perhaps when and if they want to put in rebuttal evidence, but I guess as far as tomorrow, we are going to require that each side get the same amount of time, and the old rule is that adults start losing their attention after about 20 minutes. We're all adults here, and I just commend that to you. Hour and 40 minutes is a lot longer than 20 minutes, but we'll sit here and listen to you for as long as you can go. But we would require that each side have an equal amount of time. And when I say that, I mean plaintiffs and all defendants, so that we don't have three separate sessions of 140 minutes, or an hour and 40 minutes. So without getting into too much, I don't know exactly how long it'll take to introduce evidence in the morning. That may put us past 1, and we may end up having to take a lunch break. I don't know. We may end up having to stop still at 1 if folks have made plans and come back Monday and finish closings. I don't know. It would be our hope that we can introduce evidence to the extent we need to do that first thing in the morning. And then we could start on closings. If that means that you all should reduce the amount of time each side is given in closing from an hour and 40 minutes down to an hour and 20 minutes, maybe you should. But we can finish by 1. But we want to make sure that everyone has their day in court and has the ability to say the things that they need to say. And we'll leave it at that, okay? Does that I hope that gives you some guidance.
Yes, Your Honor, we'll try to streamline things this evening, but it's good to know that if we need to take an hour and 40 minutes with Mr. Cox collectively, that we will be permitted to do so. We appreciate that very much.
Sure.
Thank you,
Okay.
Your Honor.
Sure. Is there anything else then that you all need to bring up today before we recess for the day?
Your
Legislative defendants.
Well, yes, I was actually going
Oh,
to
sorry.
say, Mr. Thompson, to help streamline things in the morning, there are 4 exhibits that the legislative defendants would like to move in that are separate from the exhibits that we're working with plaintiffs on.
Okay, let's do that now.
Okay, that would be great. Thank you. We would like to move in LX 270. It's a press release on early voting in 2016. Plaintiffs have said they had no objection to it yesterday. They just they wanted an actual copy of it, and that was provided to them.
LX 270 is received.
We also would like to move in LX 129, which are the plaintiff Fred Culp's deposition designations. We have worked those out with the other parties, and the exhibit reflects all parties' designations of his deposition.
Okay. LX 129 is received.
And then we would like to move in LX 263 and LX 262 and LX 263, which are the printouts from Senator McKissick's website that were discussed with him on his cross-examination today.
Your Honor, plaintiffs would object to admitting LX 262 and 263 as hearsay. Legislative defendants are offering them for the truth of the matter for the specific statements that are on Senator McKissick's website.
And Your Honor, he was in court. He verified that these were statements that either he made or that he had made on his behalf by an agent who he authorized to make these statements. And he confirmed their accuracy. So we believe that they come in, that they're not hearsay, but beyond that, they would certainly fall under the exception to the hearsay rule, as they were authenticated. They're from his website.
Your Honor.
LX 262 and 263 are received for impeachment purposes. And this seems like it's of the same vein, Mr. Simons, that you just introduced exhibits. Isn't it? I mean, they're impeachment type exhibits. You just introduced a host of them, didn't you?
Your Honor, given the court's ruling, plaintiffs have no further comment on LX 262 or LX 263.
Okay.
No objection for impeachment purposes.
All right. What other exhibits do you have, Ms. Moss?
That is all apart from the handful of exhibits that we are working with the other parties on to finalize, and we'll present in the morning.
Okay. All right. Anything else then before we recess for the day? I haven't heard from Mr. Cox or Mr. Steve much. You all have any wise words of wisdom that you want to add to the mix?
No, Your Honor, I don't think that with the collective wisdom available for the court, I don't think that we have anything to add.
Very well. Thank you, sir. Well, I hope that you all have a good afternoon and a good evening. We'll see you back here tomorrow morning at 9 a.m. 9 a.m. tomorrow morning. Go ahead and recess for the day.
Thank you.
Thank you.